I'm not trying to make you feel any worse than you already feel. But honestly, they're dead because you picked up a gun. Whether you knew it was loaded or not, you picked it up, you pointed at him.
Do you want us to start now?
Yes.
Thank you so much for granting us this opportunity to come before the court today to hear our motion. As the court may recall, this trial, it was
Yes.
A very intense trial.
I recall the facts.
I know you recall the facts.
Mine's a steel trap. I can tell you the entire case.
I know. And Judge, you and I, we've talked, not in terms of this case, but I know sometimes you think I talked a little more than maybe is necessary.
No, I do not. But it's okay if people want to be Charles Dickens and get paid by the word. I'm fine with that.
So I don't want to do that.
No, you can. I'm serious.
Okay. All right. So as the court recalls, again, this, was a very intense trial. And I'll just basically, I know you know the facts, but just, to talk about the facts again on behalf of Miss Castillo. This was an
playing with guns.
Well, Judge, let me say it. They had been together the entire day, not playing with guns, going to the store, doing just different types of things. Her boyfriend was playing with the gun. And in fact, a few days earlier, I think he had played with the gun. Had nothing to do with Miss Castillo. On the day of this event, the boyfriend had a gun in his hand. Miss Castillo was attempting to leave. They wanted to go. They were planning on going out. He took the gun and he was playing with the gun that had a beam of light on it, and he was pointing it at her. His cousin comes into the room, says to Miss Castillo, "You're going to let him do you like that?" Takes a clip out of his gun. His cousin's 18 years old, takes a clip out of his gun, hands it to the evidence is either he hands it to Miss Castillo or he throws it on the bed. There was some contradiction as to how that happened. But at some point, Miss Castillo gets the gun, the clip is out of the gun. She thinks the gun was unloaded. Next thing you know, her boyfriend is shot.
All right. So let me just say this. The way I remember the trial is that she was coming out of the shower. She was in a towel. The boyfriend had a gun. His mother had bought him as a Christmas present laser pointers that had the Christmas colors. He pointed his gun at her. It had a green laser on it. His brother tells her, "Hey, are you going to let him do that to you?" And she picks up a gun off the dresser. That's the way I remember the facts. There is nothing about a clip being taken out of the gun. She sees a clip out of the gun. That's the way I remember the trial.
Okay, Judge, and I respectfully want to correct you with that. And she is up to date on all monies. She's paid all monies. She's done all courses that have been presented for her to do, including a parenting class. She's done all of her community service hours, 200 hours of community service. She is gainfully employed. She's raising her now 2 children. She had a son at that particular time. Her son is a straight A student in school, well-adjusted to school. She has done everything that this court has asked her to do. She is not putting this behind her because she loved the young man that was killed. That was her friend. And this has been devastating to her. And obviously, it's always devastating to the family. You can never get around that. And you would not try to get around that. But I believe that Miss Castillo has presented herself well before this court. I don't think you've had any trouble out of her. And she's just tried to comply with everything she's supposed to do. I've kept in touch with her over the years and with her family over the years to see how she's been doing. Having another child, continuing to be employed, keeping up with her probation. I'll talk with her about it. And she says, "Yes, Mr. Marshall. Yes, Mr. Marshall." So I just think that she is a worthy candidate. She is a worthy candidate for early termination on this case. And I would ask that the court would consider terminating her probation.
For argument or about the facts, Judge? Because you're the one with the facts.
No. I'll hear your argument.
Yes, Judge. At this point, a jury did, hear all the facts and they heard them as you did, Judge, and they still returned a verdict of guilty. And as we know, they have the option of assessing as low as 2 years if they were going to give probation. The jury chose, after hearing all of the facts and hearing all of the argument, the jury chose to give her 10 years, which seems to be deserved for probation, Your Honor. It does seem like this was a probation-worthy case, but they still chose to assess the maximum amount of probation being 10 years. And we would just ask that the state follow that, or that the judge follow that. Because then at the end of the day, a young man lost his life. And as we both know from other, expert testimony, just because there's not a clip doesn't mean that the gun's not loaded. And first rule of gun safety, you don't point a gun at somebody unless you intend to fire it.
Okay. And if I may, Your Honor, that's just not the facts of this particular case. I believe the fact in this case, which was undisputed, that she had never personally handled a gun before. Also, when talking about whether the gun fell to the ground or not, I don't believe our argument was that she dropped the gun. Our argument was that because of the type of gun it was a gun that had been known to have a quick trigger. And so questions were elicited as to whether or not, if the gun was dropped, so on and so forth, would it fire? And our expert, which we knew what he was already going to say, basically said with respect to that gun, no. But what we were really getting to was the nature of the quick trigger in this particular case, because there was some issue as to whether or not this gun fired with a quick trigger. And so when having the gun in her hand, is she intending on firing the weapon, shooting her boyfriend, so on and so forth? No to that. But we were, eliciting questions as to whether or not, or answers as to whether or not the gun had a quick trigger. And so our expert witness said he did not believe, in his expert opinion, that particular weapon, although that style of weapon was known to have had a quick trigger, he didn't believe that particular one did, because he was not able to test that gun until, I believe, the day of trial. I think the day he testified was the day that he was able to look at that gun on the stand, actually, is when he was able to do that.
And I believe afterwards, both you and the state's attorney came before the court after this was all over and asked the court, hey, if we would have came for you on an open plea. Do you remember that conversation?
And I believe you said that you would have given her deferred adjudication.
No, what I said was that if you all had come to me on an open plea, that I would have given her deferred, because these were two young children playing around with guns. That's what happened. Two young children playing around with guns. And I said their parents were allowing them to play house and play around with guns. And I would have given her deferred adjudication. But where we are now is she hasn't even done 5 years on probation yet. And in the big scheme of things, somebody is dead. I understand that she loved him. I do remember the facts of the case. I remember her being on the sidewalk when the police came, and she was telling them that she shot him. And the complainant's mother is saying she doesn't know what she's saying. She's in shock. Robbers came in. I remember that. So I want you to know that I remember all of this. I remember that you were very distraught because the person that you loved died, right? And I know you didn't mean to kill him. That's why it's a manslaughter case. And I know that part of the fault, and I don't like to pass blame around, but parents should not have allowed children to be playing with guns. And I remember listening to the testimony, thinking to myself, I didn't know laser pointers now come in Christmas colors, holiday colors. Why are people marketing holiday colors for people, and especially children? But my problem with this case in granting you early term is you haven't even done 5 years yet. This is from 2020. You need to at least have done half the time. And I know you can come forward at a third of the time, but at the end of the day, someone's dead. And I'm not trying to make you feel any worse than you already feel. But honestly, they're dead because you picked up a gun. Whether you knew it was loaded or not, you picked it up, you pointed at him, and you fired. So you should at least serve half the term before you come to the court asking for early term. You understand?
Yes.
All right. So at that point, I will strongly consider your motion for early termination. But now you've just been on since 2020. And I know sometimes people rush through conditions that are given to them. And I appreciate that because I want you to do it. You appear to be on the right track. You're doing what you need to do. But a third of the time and somebody's dead is not enough in this case. You understand?
Yes, ma'am.
So come back when there's 5 years that have elapsed and the court will strongly consider your motion for early termination. Do you understand?
Yes.
All right. Thank you.